Hi, my name is Jason Wapiennik. I'm an attorney with Great Lakes Customs Law. And in this video, we're going to be talking about receiving a penalty for importing counterfeit goods into the United States. Now, counterfeit may not always mean what you think it means. Counterfeit goods can be simply a word on product packaging. It could be the unauthorized use of, for instance, the word Apple, or the word iPhone, or the word HDMI, or the word Bluetooth. Having those types of things on packages, even though the goods themselves are not trying to duplicate something that is made by those companies, can still be considered a counterfeit and subject to seizure, forfeiture, and penalty under the customs laws. Now, customs uses the ability to issue penalties in order to discourage bad behavior. Generally, somebody will receive a penalty for importing counterfeit goods into the United States when they've had more than one incident where they've tried to import goods into the United States and had them seized. A typical case would be somebody tries to order something counterfeit into the United States. They seize it, frustrated. The person thinks that if they order it again, they're going to be able to get it past customs. Customs finds it again, seizes it again, and they realize there's a pattern developing, and they want to put a stop to this kind of activity. In a case like this, customs will issue a penalty in order to try to put a stop to it. A penalty for importing counterfeit goods is issued under the authority of the Anti-Counterfeit Importation Law, 19 United States Code, section 1526. And basically what the law says is that you can't import counterfeit goods into the United States. And if you do, customs can impose a penalty for the first violation of 1 times the manufacturer's suggested retail price of the goods if they were genuine. So this isn't the price that you paid for them, very likely. It's the price that if the goods were authentic, if they were real, if they were not counterfeit, that they would go for according to the manufacturer's suggested retail price. So this price is probably much, much more than the price that you paid for the goods if you knew they weren't genuine at the time that you bought them, or you just thought you were getting a pretty good deal on something that was genuine when in fact it turns out to be counterfeit. If customs sends you a penalty for more than one violation, if there's been more than one seizure and forfeiture of counterfeit goods into the United States, the penalty that they issue can be double the manufacturer's suggested retail price. So this goes to a repeat offender who has had this happen to them more than once, and customs, in order to discourage that bad behavior, customs sends out a higher penalty. Generally, first you're going to have noticed that the property was seized before you receive the penalty. Not always, but generally. After you receive the seizure notice, it may be some days, weeks, months, or perhaps even a year after customs sends the notice of seizure and the property is forfeited that you finally get a penalty notice. So it may be unexpected. The penalty notice will say that you have 60 days to pay the amount or file a petition. Customs will look at aggravating and mitigating factors to determine whether or not they should reduce or mitigate the amount of the penalty that they've sent to you. So if you file a petition, there's a good chance you won't have to pay the full amount of the penalty if the factors that customs looks at are in your favor. Now, mitigating factors can be things like inexperience in importing, having a prior good record with customs. So you import regularly and you have not had any violations like this. Other factors can be you did not know that the goods were counterfeit. Genuinely, you believe that you were trying to import something that was genuine, and basically you got tricked. Extraordinary cooperation with customs. That's a little bit more difficult, but a scenario that comes to my mind is you provide customs with full information of the person that tricked you, and give them more information than they would otherwise have if you weren't cooperating with them. Finally, a mitigating factor is inability to pay, as determined by CBP's Office of Regulatory Audit. So that's just not throwing your hands up in the air and saying, geez, I can't afford this. There has to be some proof, okay? You have to actually pass a test to demonstrate that you can't afford to pay the penalty that they have imposed. And then there's aggravating factors. These are things that make you look worse. This could be whether or not you've done this before. Have you had a previous seizure? Did you have warning that this type of behavior wouldn't be acceptable to customs? Was there a criminal violation or a criminal charge that came with it? Have you been dragged into court and charged criminally for trafficking in counterfeit goods? And another one is whether or not you've submitted false documents as part of the process of importing the goods into the United States. And to me, this one's probably almost always present, because if you're importing goods into the United States that are counterfeit, very likely the package isn't going to identify them as counterfeit. So this is a broad mitigating guideline that I think probably a lot of people would fall under. But let's assume you file the petition and you weigh all of these different factors, and what is the expected outcome? What is customs going to do for you once you file the petition? Well, they're going to reduce the penalty potentially to as low as 10%, sometimes more, okay? The mitigating and aggravating factors that I've talked about, it's not an exclusive list. They can consider other things, and that's something that a good attorney would be able to help you put forth your best case to try to get those penalties reduced as much as you possibly can by identifying mitigating factors that may not be on the list. And if you don't do anything, you receive the penalty, you decide not to file a petition, well, then they refer the case over to the Department of Justice, and the Department of Justice will look at things and decide whether or not they want to sue you for the full face amount of the penalty, in which case then you are dragged into court, maybe not on criminal charges, but they will drag you in to try to get a judgment against you so that they can collect money, garnish wages, garnish bank accounts, and things like that in order to satisfy the penalty. So it's a good idea to respond to the penalty notice by filing a petition. And even if maybe you missed the penalty notice and you've got a bill or time has run out, sometimes customs will allow you additional time to file a petition. Sometimes, even if they don't do that, you're going to have the ability to make an offer in compromise, which is a settlement offer to the government, to try to get them to drop the penalty case and accept some amount of money in exchange for dropping the case against you. Either way, we're here to help. Make a visit to our website, GreatLakesCustomsLaw.com. Give me a call, 734-855-4999. Be happy to look at your notice of penalty or your bill or whatever you have in your hands that you're worried about relating to a counterfeit importation into the United States. And we'll be able to advise you about what we can do for you to get that penalty reduced so you don't have it hanging over your head.